Guidelines for understanding the testimony of false confession experts. We recently received an email that stated the following. I'm an investigator with the XYZ Police Department. A few years ago, a co-worker and myself obtained a confession from an individual which was key in their conviction. He has recently filed a motion for post-conviction relief of his sentence due to what he is claiming ineffective counsel by suggesting that they did not object to the Reid technique being utilized. According to an expert hired by the defendant, the expert is claiming that using Reid to solicit confessions is a violation of his rights, and a confession using this method should not be admitted as evidence because it is unduly coercive. Oftentimes, we are contacted by investigators like this and attorneys who are dealing with a quote-unquote false confession expert in their case, and they are inquiring about what to expect from the expert's testimony and what potential responses might be helpful. Over the years, we've published a number of articles discussing the issues raised by false confession experts and have posted them on our website at reid.com, typically under the tab Investigator Tips, which you'll find on our homepage listed under the heading Resources. In this brief PowerPoint presentation, we will reference those articles and suggest that any investigator or attorney dealing with a false confession expert in their case, or simply dealing with the issue of a possible false confession from the defendant, should review these articles. First off, many false confession experts oftentimes, and I think in some cases intentionally, misrepresent what the Reid technique is. The following investigator tips will be helpful for you to review in anticipation of them misdescribing the Reid technique process. A description of the Reid technique, principles of practice, how to conduct proper investigative interviews and interrogations. Don't be fooled, they use the core elements of the Reid technique. The following articles will detail what false confession experts say about the Reid technique in particular and include our responses. What false confession experts say about the Reid technique and our responses. The disingenuous testimony from social psychologists about the Reid technique. A general outline of Richard Leo's testimony on false confession issues and Reid's responses. Clarifying misrepresentations about interrogation techniques, updated May of 2023. The truth about the research social psychologists use as the basis for testimony regarding false and/or coerced confessions. General information regarding false confessions. False confessions, the issues to be considered. What questions should be asked to determine the voluntariness and validity of a subject's confession? Courts and attorneys oftentimes use Reid as the benchmark for proper procedures. Here are some comments from the courts about the Reid technique. For example, with respect to the interrogation of juvenile and/or mentally disabled suspects, it is interesting to note that several cases the courts have used our guidelines for the questioning of such individuals as the means by which they are measuring the validity of the confessions in their respective cases. So, for example, in People v. Elias, the appeals court pointed out several prescribed Reid procedures that were not followed by the investigators, resulting in a confession that was found to be involuntary. Number one, they did not conduct a non-accusatory interview before initiating an interrogation. The investigator misrepresented evidence in the case when questioning a 13-year-old juvenile. There was no corroboration of the incriminating statement made by the youngster, and there was contamination where the investigator gave the subject some of the details about the crime. In another case, U.S. v. Preston, the U.S. Court of Appeals reviewed the confession of an 18-year-old with an IQ of 65. The court pointed out that the investigators did not follow the cautions we suggest when interviewing individuals with mental limitations. quoting from the court's opinion. Among the police tactics used here were several recommended by a manual on police interrogation, see Imbaugh, Reid, Buckley, and Jane, Criminal Interrogation and Confessions, from which both the officers who interrogated Preston were trained. The officers, however, sometimes disregarded the manual's cautions about the tactics they used. For example, using one of the recommended approaches, the officers asked Preston a number of questions with two alternatives as how the crime was committed. These questions were derived from similar exemplars in the Reid manual. The manual, however, suggests that the inculpatory alternatives technique recommended may in fact be unduly coercive when used for suspects of seriously impaired mental ability and therefore should not be used. In July 2014, at the National Association of Criminal Defense Attorneys Conference, the attorneys were encouraged to use the information on our website, reid.com, and our book, Criminal Interrogation and Confessions, as a reference for proper police practices. During the presentation, attorney Laura Nereider told the audience that there's a lot of gold in the Reid Interrogation Manual and on reid.com, and we really encourage you guys to go there and cite that material. She was describing how to use the Reid material as the foundation for proper procedures, then point out how the officers in your case deviated from those procedures. Some social psychologists oftentimes try to suggest that the Reid technique causes false confessions, but typically such statements are clearly not supported by any evidence, as the courts typically recognize. For example, in U.S. v. Jocks, the false confession expert was Professor Alan Hirsch, H-R-I-S-C-H. And from the court's opinion, quote, in his declaration and at the hearing, Professor Hirsch explained that the primary cause of coerced compliant confessions are certain interrogation methods employed by law enforcement, including a widely used method known as the Reid technique. Beyond his own intuition, however, Professor Hirsch offered no basis for concluding that these tactics had any tendency necessarily to cause false rather than true confessions. The court went on to say that Professor Hirsch's declaration offered no other evidence of the danger of certain police interrogation tactics, and the Reid technique in particular, except to say that, quote, the use of these tactics and their correlation with false confessions are extensively documented in the literature. Despite this broad statement, however, he did not provide any further explanation. The court stated that in summary, the proffered expert testimony to the effect that the Reid technique enhanced the risk of an unreliable confession lacked any objective basis for support whatsoever. Although Professor Hirsch insisted there is a wealth of information about the risks of the Reid technique, he could point to none. In State v. Belonde, the Superior Court of New Jersey stated in their opinion that, quote, no case supports the contention that using the Reid technique renders an adult's confession inadmissible. A suspect will have a natural reluctance to admit the confession of a crime and furnish details. Therefore, an interrogating officer may dissipate this reluctance and persuade the suspect to talk as long as the will of the suspect is not overborne. The court went on to say that recognizing that questioning of a suspect almost necessarily involves the use of psychological factors, our Supreme Court held that appealing to a person's sense of decency and urging him to tell the truth for his own sake are applications of psychological principles and are permissible. Likewise, that the fact that the police lie to a suspect does not by itself render a confession involuntary. Ironically, Richard Leo, a staunch critic of law enforcement interrogation techniques and the Reid technique in particular, uses Reid as the standard for proper procedures. In several cases in which Leo has been retained by the defense to challenge the confession secured by the police, he he has testified that, quote, the Reid and Associates manual is sort of the Bible of interrogation in America. It was then and it is now. When he was asked by the attorney, well, what actions did the officer in this case take that you are opining violated national police interrogation standards, he testified, one would be the use of promises or threats, which Reid has advised investigators not to do for over 60 years. Leo has also testified that, quote, the Reid and Associates training manuals and programs have always, from the first edition in 1942 to the current edition in 2022, repeatedly implores police investigators not to use any interrogation technique that is apt to make an innocent person confess. Given the fact that Leo and others use Reid and Associates as the standard for proper procedures, it's clearly disingenuous for them, on the other hand, to try to suggest that we engage in and teach behaviors that cause false confessions. For additional information on this entire topic, I would recommend that you see our book, Criminal Interrogation and Confessions, 5th edition. Thank you very much for taking a few minutes to listen to this presentation.